All right, good afternoon. It is March the 21st at 4:30. Well, we're going to say 4:30. So we show starting on time. Welcome to Criminal Justice Full Committee. Madam Clerk, will you take the roll, please?
Representatives Campbell, Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Sherrill, Towns, Vice Chairman Gillespie, Chairman Holsey.
Here.
Mr. Chairman, you have a quorum.
Thank you. Are there any personal orders from the committee? No personal orders. All right, we'll get right down to business then. First up is House Bill 1029 by Chair Lady Littleton. Second. You have a motion and a second. Chair Lady recognized.
Thank you, Mr. Chairman and committee, but I would like to roll this for 2 weeks, please.
All right. Without objection, we roll for 2 weeks.
Thank you very much.
We're now on House Bill 1030 by Chairman Doggett. Motion. Motion and a second. Chairman, you recognized.
Thank you, Mr. Chairman. I have an amendment. Drafting code is 6091.
Motion. Second.
We have a motion and amendment on the motion and a second on the amendment. All those in favor say aye. Aye. All opposed, no. The ayes have it. The amendment's on the bill. Go ahead.
Thank you, Mr. Chairman. The amendment rewrites the bill, and therefore legislation makes changes to the current repeat violent offender law. This is vital for holding repeat violent offenders accountable for their actions while also protecting victims and the public. Simply, this legislation states that for repeat violent offenders, if they receive 3 strikes for committing violent offenses, they will be sentenced to life in prison without the possibility of parole. And Mr. Chairman, I believe we have someone here for testimony today.
All right. We will go out of session to hear testimony. First up is Mr. Raphael Mangual, I believe is the correct way, from the Manhattan Institute. Sir, please state your name for the record and begin.
Okay, thank you very much. Good afternoon. I appreciate the invitation to testify on this really important issue. My name is Raphael Mangual. I am the Nick O'Neill Fellow and Head of Research for the Policing and Public Safety Initiative at the Manhattan Institute for Policy Research. What I want to do in the limited time that I have is, 1, explain the potential benefits of pursuing what is colloquially known as a 3 strikes regime, and 2, offer my thoughts on potential changes that this body may want to consider in order to maximize those benefits and also minimize the potential excesses of this kind of regime. Now, there are 2 overarching rationales for this kind of policy. 1 is illustrated by the deterrent effect of the policy on individuals who might be subjected to the enhancements as a result of their criminal histories. The other is that by incarcerating repeat offenders for lengthy periods of time, society will enjoy the benefits that attend their incapacitation. Now, both of these rationales find support in the available research. For example, a 2007 study of 3 strikes in California found that offenders in that state with 2 strikes were 17 to 20% less likely to be rearrested for a new offense than similarly situated offenders with just 1 strike or no strikes, highlighting a sizable deterrent effect on the discrete population of offenders that the bill was aimed at. On the incapacitation front, a trove of data from jurisdictions around the country makes clear that the most serious violent crimes, particularly shootings and homicides, are consistently committed disproportionately by offenders with extensive criminal histories. Now, research from the Bureau of Justice Statistics found that between 1990 and 2002, well over a third, 36%, of those convicted of violent felonies in America's 75 largest urban counties were either on probation, parole, or on pretrial release at the time of their offense. In the city of Chicago, the University of Chicago Crime Lab found that on average, someone charged with a shooting or a homicide in 2015 and 16 had 12 prior arrests. 1 in 5 had more than 20 prior arrests, which is something that we see in cities across the country, including Washington, D.C. and Baltimore. A three strikes regime can be an effective way to prevent such offenders from re-victimizing their communities after they've made clear through their repeated criminal conduct that they have no intentions of playing by society's rules. However, by restricting strike-eligible offenses to violent felonies, HB 1030 in its current form may leave money on the proverbial table. Why? Because the criminological literature suggests that the extensiveness of a criminal history is more predictive of future risk than the nature of that history. As such, I would suggest considering a step system in which offenders accrue anywhere from a quarter strike to 1 whole point for any convictions, with misdemeanor convictions resulting in 1/4 strike, non-violent felony convictions resulting in a half a strike, weapons felonies resulting in 3/4 of a strike, and violent felonies resulting in 1 strike, excluding traffic offenses other than DUI. This process also, I think, presents an opportunity to craft a strike regime in a way that responds to the important critiques of older three strikes laws. One, by limiting the high-end enhancements to cases involving felony convictions so that repeat misdemeanors will not be subject to multi-decade prison sentences. And two, by rewarding desistance through the subtraction of strikes based on good behavior while an offender is free. Now, again, I'm encouraged by this body's interest in addressing the problem of repeat criminal offending, and I look forward to answering any questions that you all have on how best to do so. Thank you.
Thank you, sir. Questions from the committee? We have Vice Chair Gillespie. Go ahead.
Thank you so much, Mr. Chairman. Raphael, thank you so much for being here as well. We got a moment to kind of briefly meet earlier, and I didn't get really a chance to ask you anything specific. I'm from Memphis, and Memphis right now is experiencing, and have been for quite some time, a extremely large amount of repeat violent offenders committing all sorts of heinous crimes, from 11-year-olds that are carjacking people all the way up to, you name it, the adults that are committing crimes. And I just wanted to get your take, and if you could elaborate a little more into other cities across the country that are similar to Memphis, how I believe this would help us. But if you could elaborate, are my constituents' biggest fears are we have a revolving door through our criminal justice system, and I don't know what the statistics are, but I know more than half of those people that are committing these violent crimes are going in and out and in and out and in and out. And I know that you have some data that can substantiate that, and some other cities that have seen similar problems as Memphis is going through right now. Thank you.
Yeah, no, I mean, that's a big problem that we see across the country. I mean, if you look at the most serious offenses in any jurisdiction in America, and you look at the typical profile of the people committing those offenses, what you're going to find are individuals with very extensive criminal histories, and that tells you two things. It tells you, one, that the police are still doing a relatively good job of concentrating their resources on problem actors, but it also tells you that the criminal justice system is failing in a really important way to incapacitate the people that the police are bringing up to the criminal justice system. I already mentioned the statistics out of Chicago, where on average a shooter has 12 prior arrests, 1 in 5 have more than 20. Commissioner Robert Conti Jr. out of Washington, D.C. was just on the news the other day where he said in his city, the typical homicide suspect has 11 prior arrests before they have committed a homicide. In the city of Baltimore in 2018, the police department there identified 118 murder suspects from the prior year. 70% of them had at least one prior for a drug offense. 90% of them had at least some kind of criminal history, and the average number of prior arrests for that group was 9. Right? If you look at our prison population, right, these are individuals, the majority of whom have been convicted of really serious violent or weapons offenses, and you look at the cohorts of released state prisoners in 2005, 2008, and 2012 that have been tracked by the Bureau of Justice Statistics, what you're going to find is that on average they have between 10 and 12 prior arrests and between 5 and 6 prior convictions. And what this belies is the notion undergirding a lot of the criminal justice reform proposals that have been put forth that I think have exacerbated this problem, and that narrative is that we in this country systematically deny second chances. I'm all for second chances. I think lots of people should be. I think we should be for third chances too. What we shouldn't do is allow repeat criminal offenders to consistently flout the law mostly because what that does is it rolls the dice with the lives of the people who are stuck living in the very, very small pockets in which crime concentrates. And those people have enough disadvantage already to deal with. Exacerbating that by subjecting them to the repeat criminal offending of people who show no desire to improve their behavior can be really problematic.
Okay, thank you, Representative Hardaway.
Thank you, Chairman, and good afternoon, sir. Interesting presentation. I didn't hear you mention any of the rehabilitation efforts and how they factor. Do you have metrics that will help us to understand what the impact was on the repeat offenders, how the rehabilitative efforts have succeeded or failed, or mix of the same? How does that all jive?
I mean, I think there's been a pretty clear failure of rehabilitation efforts in this country over the years, in part because rehabilitation is really, really difficult to do. Psychological interventions have not been shown in a systematic way to significantly reduce likelihood of reoffense. We see that in the recidivism data at the national level. So state prisoners in the United States over a 10-year period recidivate at a rate of 80 to 83%, depending on the cohort that you're looking at, which means that less than 20% of individuals are actually desisting from crime over that 10-year period. On average, over that 10-year period, people released from state prison will be rearrested 5 times, which is, of course, an undercount of the actual criminal activity that those individuals engage in, because 1, most crime is not reported, and 2, most crime that is reported doesn't result in a clearance or an arrest. And if you look at the meta-analyses on the effect of rehabilitative efforts, they're very, very mixed in terms of research findings. The very few rehabilitation programs that do show some promise suffer from a couple of shortfalls. One is that their observation periods are relatively short. So you're looking at 24 to maybe 36 months, which means that if you extend the period, we don't know whether there's a regression back toward the mean, say over 48 months or over 10 years. The other thing that you find is that it requires a lot of intensive small group or one-on-one therapy, right? So right now in the criminological literature, the sort of consensus is that you need about 200 hours with an individual offender in some kind of therapy setting. To scale that across a prison population as large as the prison population that we have here in the United States raises a really difficult problem that I don't think we have clear answers for, which is why I think you all should really consider an approach that sort of elevates incapacitation as the primary rationale through which you seek to reduce crime.
When you say elevate incapacitation, you're saying that we need to put more into the rehabilitative process while an individual is incarcerated, and to look at the frequency as opposed to the severity of the crime?
No. When I say elevate incapacitation, I'm saying that when you are prioritizing the penological ends that you're pursuing through crime policy, incapacitation should be at the top of the list, precisely because we don't know how to reliably rehabilitate, let alone how to reliably rehabilitate at scale. I do think that we should continue to invest in efforts to identify rehabilitative programs that will show promise and that can be scaled, but until that happens, I think the responsibility should be on reducing the ability of those offenders victimizing their communities, and the only way that we can do that reliably is to incapacitate them through incarceration.
And I'm not sure whether your background includes work in rehabilitation or whether you're more of a statistician.
Right.
So when you're looking at the programs, have you seen a difference state to state on what type of programs are effective, which ones are not, when it comes to rehabilitation?
Not really, and I don't even think that, again, I wouldn't say that I'm an expert in the rehabilitation literature, but I'm familiar with it, and I don't think that you can read that literature to fairly say that there's a formula for rehabilitation that works regularly. I mean, what you find is that one rehabilitation program that works cannot be replicated in a larger population, or cannot be replicated with a same size population in a different facility, because the quality control measures aren't there. Sometimes what really matters is the quality of the individual actually delivering that service. And one thing that I've found in my research is that the CDC predicts a shortfall of mental health professionals over the next 10 years across all kinds of different professions. But that's going to include people who are doing the kind of important work of deploying psychological interventions in carceral settings. And so, again, I just don't think that there is a body of research you can rely on to say that rehabilitation is a viable means of crime reduction, at least relative to what we know we can get through the incapacitation effects of incarceration.
All right. Thank you, Mr. Chairman. And some things I'm in agreement with you on, some things I'm not. And I don't think you, from my interpretation of what I've heard from it, you're not 100% with the way the bill is written. And I'm having a problem with most of it because I think everyone has a point where there is some positive rehabilitation response to the efforts. And if we're removing the motivation, even these hardcore criminals, and if we're talking about locking them up for life, et cetera, it's just, I'm not for that. I think everyone ought to have an expiration date. And if at that expiration date, if they're not ready, then fine, extend the expiration date. But I don't think that we, as you stated so eloquently, I don't think we know enough about the ability to impart psychological help and counseling and being able to set metrics to accurately measure the results. And I dare say if we throw everything out right now with legislation that just warehouses men and women, we never will get that data, and we never will start to improve that part of the population that needs our help the most. So, but thank you, sir. Thank you, Mr. Chairman.
All right, Leader Lambert.
I don't understand, based on the data that you have analyzed, and I've been practicing criminal law for almost 20 years now, and it sounds like what you're saying is that the data supports the fact that if someone commits a violent crime over and over again, that they are more likely to stay in that rut and do it again. And that if we incarcerate them for longer, then the community is safer. Is that basically what your research shows?
That's exactly right. I mean, the incapacitation of people who continuously offend is at the core of, I think, a proper approach to public safety. Now, the one quibble I'll have there is that, as I mentioned in my prepared testimony, I do think that there is money being left on the table in the sense that by only restricting strike-eligible offenses to violent felonies, right, we are ignoring something that's really important, which is that if someone has 10 prior convictions, say only 1 or 2 of which are for violent felonies, and another person has 3 violent felony convictions, the person with the longer conviction history is much more likely to be a future risk. And so I think you want to be very careful not to narrowly construe legislation that sort of that limits your ability to, through incapacitation, reduce crime. Because if you were to profile the sort of average homicide suspect in this state, my guess is that not a huge proportion of them are going to have 3 prior felony convictions before they ultimately commit a homicide. So if the goal of this is at least in part to reduce homicides by getting people off the street before they get to that point, then I think one thing that you have to look at is expanding the type of offenses that will contribute to someone's strike count, albeit in varying ways, so that you can actually take that individual off the street before they end up killing somebody.
Yes.
Thank you. And did I hear you in your prepared statement a while ago say that after 2 strikes in California, so after they've committed 2 offenses, that it was 15 to 20% less likely that they would commit that 3rd violent felony?
17 to 20%, yeah. 17 to 20% reduction in rearrest for people who had 2 strikes compared to similarly situated offenders who just had 1 strike or 0 strikes. Now, in theory, you could say that that effect is driven at least in part by those offenders being more careful not to get caught. But that in and of itself reveals the deterrent value. But my guess is that, you know, a good portion of them just simply desisted by virtue of the fact that they knew that they stood to face a life sentence if they were convicted again.
Thank you very much. I know you've written a book, and I'm looking through that as well. But it's glad to have some data to support what we've been seeing in the court system for decades. Is that you've got a very small number of individuals that are committing most of the violent crimes, and it's the folks you see all the time. And so it's not working to have a revolving door in the prison system. I would rather we focus our efforts on juvenile offenders, on early offenders that have not committed violent crimes yet, and really, really lean in on making sure they get the services that they need. And for some of these folks that are just going to continue to commit violent crimes, yes, absolutely. I mean, it sounds like your data supports those folks need to be incarcerated for lengthy periods of time. So thank you.
Thank you.
All right, Representative Johnson.
Thank you, Mr. Chairman. So the research that you cited, a lot of that was from California, correct?
One piece was from California. Yeah.
Okay. And so California is one of those states that also allows nonviolent offenders, where most of the other states require it to be all violent offenses. Is
That's
that
right.
correct?
Yep.
Okay. So what you were saying, it sounds like to me, is it's almost as if, you know, someone's doing a lot of these nonviolent offenses. We're going to go ahead and lock them up because perhaps they're going to do something bad in a few years. It sounds like you're using that as a predictor.
Well, yeah, I mean, criminal history does have very high predictive value in terms of predicting the risk of future offenses. You know, we have, for example, lots of jurisdictions around the country use algorithmic risk assessments to make pretrial release decisions. And if you look at the validated risk assessment tools that have the highest level of accuracy, the factor that gets offered the most weight is criminal history because it does have the most predictive value. So if what you want to do is prevent the most serious kinds of crimes, which are generally committed by repeat offenders, you want to ideally craft a policy that is going to reflect the criminal record of your median, you know, homicide offender or rape offender or, you know, serious violent offender, so that you can actually prevent that crime before it happens. So yeah, there's certainly a predictive aspect to this. I mean, I also think that there is, you know, incarcerating someone who continues to offend repeatedly, even if those offenses are nonviolent, is still a good unto itself.
But you've basically removed any idea of prevention or anything else, as discounting it as not successful, and let's just go ahead and incarcerate them so they won't do something bad in the future. I just see that as a serious problem.
All right, Representative Fritz.
Thank you, Mr. Chairman. Does your work include approximations of capacity demand on jails and prisons based on the three strikes or the graduated three strikes approach that you talked through?
No, it's not something that I've looked at. I mean, I don't have a good sense of what the capacity is in Tennessee. You know, but carceral capacity is absolutely an important point and something that you'll want to assess in terms of what the future impact is going to be. I mean, at the same time, you know, there is still a case for, you know, making sure that that carceral capacity is being put towards its highest end use. And so if you get to a point where you're sort of approaching limits, you want to make sure that you're identifying the offenders that pose the biggest risk, which is one of the reasons why I think, you know, it might be worth looking at how to expand strike eligibility beyond just violent offenses, because, again, I think the most serious offenders have a more complex criminal history.
Thank you, Mr. Chairman. Just make sure I got that the carceral impact, you're suggesting there may be a favorable, reduced demand if we looked at a more graduated three strikes approach. Is that what I'm hearing?
Right, because someone won't get to number three as quickly necessarily. You know, again, if you're giving a quarter strike for certain kinds of lower level convictions, but you're also, you know, have something built in where longer periods of desistance, say, 3 years, result in the elimination of half a strike, or 5 years results in the elimination of a strike, which I think is an important element to consider here, because I think you want this policy to be responsive to the critiques of other 3-strike regimes from the past. That might, I think, help alleviate any pressure that you might have otherwise expected on carceral capacity.
All right, Representative Towns.
Thank you, Mr. Chairman. Tell me your name again.
Rafael Mangual,
Where are you from, man?
Brooklyn, New York.
Brooklyn, New York?
Yes, sir.
What you know about the South? Nothing?
I don't know. That's a
That
broad
means
question.
nothing to me. Okay. Look, when I hear you talk about robots or machines, or you didn't say that, you said statistical analysis and predictive value, that you give a certain quantity to make a decision. That makes me think about machines, robots in the military that we don't utilize to kill people because there's no, what you would call, conscious. And we have the ability to go out and just kill in the war with machines. No human element at all involved in it. Your statistical analysis generally gives me that impression, okay? That you're taking out, or you're trying to take out, or you are with that approach, nothing as it relates to human beings making a decision. And we're supposed to be smarter, I don't know, than those machines at some point. But so how do you have a prison system that does not have the human element in, and how do you deal with a graphic or data that just generally just does not have the capability specifically saying this guy or lady will commit versus that one?
Well,
Your statistical data will say generally they will, so everybody has the same policy. So how do you address that?
Yeah, I mean, I'm certainly not advocating removing the human element. I mean, obviously, this law would reflect human deliberation, and there's, I imagine, going to be prosecutorial discretion in terms of charging, with respect to the eligibility that a particular charge has for strike accrual. So you're not taking the human element out, but the other thing I would say is that there is absolutely a human story undergirding the rationale here, and that is the human story of the potential victims that you are trying to save, right? I mean, when you hear a story like the one I began my book with, which is the story of a 24-year-old woman named Brittany Hill who was murdered on the west side of Chicago, she was murdered on video. You can watch it. You can go and Google it. And what you'll see is that she's standing in front of her house on a bright summer day in the middle of daylight, holding her 1-year-old daughter, when a car pulls up and the occupants open fire on the group. She's immediately wounded despite trying to save her daughter's life, which she does successfully. And after those shooters drive away, the police were able to make an arrest within just a few hours because the shooting was caught on video. One of those individuals arrested and charged with her murder had 9 prior felony convictions. He was out on parole and had an open case. The other guy had 5 recent charges despite just being 23 years old, including being on probation for a gun offense. So there's absolutely a human aspect to this debate. And I would just urge you to consider the human lives that I think people who are proponents of these kinds of efforts are actually trying to save.
Well, all that sounds good. I'm very familiar with that situation that you talked about in Chicago. Okay, I'm going to ask you another question. Have you ever been a victim of crime?
Yes.
More than once?
Yes.
Okay. As well as probably people here. I mean, that includes car theft or jacking or whatever you want to call it. Everybody's sick of crime, okay? I remember, I'm old enough to remember when they came out with the 3 strikes out bill. I remember how that thing played out in the community. As a result, how Maxine Waters had to come out and talk about a lot of things that happened in this country as it relates to crime. I remember as a kid, a youngster, okay? And I want you to get me very clearly. Nobody wants crime. And we hadn't figured out just how to solve it yet. Even the criminal does not want to be criminalized, okay? No human being does, okay? It's the barbaricness of us that we actually actualize this on other human beings. It happens, okay? And all of us are sick of it. But I remember as a kid as well, when the system would actually dump drugs and things in the community for political reasons. These are things you can look up, stating that they were prosecuting all these people, doing all this stuff, and it was false because they were generating the crime. and going out and prosecuting young men and women. In some cases, paying them to do things that they shouldn't have done. And their records got ruined forever. A lot of this stuff was disclosed later on in the communities, okay, which is horrible. Okay, human beings have a horrible record of being human to each other. Whether you're a police officer or a pope or a minister, it does not matter. Businessman, people do a lot of dirty stuff to other human beings. That's a flaw, I think, in human beings. We're flawed. We are. Okay, according to the book, we all are flawed. We're terribly flawed. And I've always heard that we're supposed to be rehabilitating people. Rehabilitation doesn't happen. Your book ought to be on rehabilitation as well. It doesn't happen because people don't care about rehabilitation. Who cares about rehabilitating a criminal? You, me, a few people in this room? Generally, people don't care about it. So it doesn't happen. See, at the end of our lives, we still got to give them an account of what we do to other human beings and God's earth as well. We still have to give an account. Don't misunderstand me. Don't misunderstand me at all. Because if I caught certain people doing certain things in my life as a criminal, I would kill them. No two ways about it. You meet your maker. That's just how I feel. But by the same token, on this side of the equation, I still have to do what I think is going to be spiritually right by human beings. Now, what would happen to you as a criminal that was incarcerated, you got out, and when you got out the first time, you never had a problem getting a job because people would hire you? Does your book deal with that?
I'm not sure I understand the question.
My question is this: would the recidivism rate be as high if people that actually, when they violated the law, they got out, the system allowed them to go back and work and do things that would make them whole?
I mean, I don't think the system disallows
It doesn't?
offenders from working right now. No. I'm
So
not aware
how
of
do you
any
get a
law
job
that
with a
says-
felony?
I know personally felons with jobs.
What, 2 or 3?
Excuse me?
You know 2 or 3 felons with a job?
Sure.
So that's not the general norm. People
No,
can't
But
get
I'm
jobs.
also not aware, I'm just not understanding the framing of the question. I mean, there's no law that prohibits someone with a felony conviction from getting a job. If your argument is that it's more difficult for people with felony records to get jobs, that's certainly the case. But, you know, they also more than likely did not have significant employment histories before they had a felony record either. I mean, there's nothing in the research that I'm aware of that says the felony is the actual cause of future joblessness, as opposed to the disposition that led to the criminal history in the first place.
Well, I'm shocked you would give me that jargon and tell me that there was no law. Of course, there's no law. But there's a general attitude when people begin to hire people that have those felonies that they don't have a job, that they're not employable. Of course, there's no law. Okay? But it's not just the law side equation, it's the community itself. Okay, let me ask you another question.
Hurry, because we
got it, sir.
got 2 more
Okay.
people to speak here.
What happens, in your opinion, with stock like CCA or prison stock in this country if bills like this pass around the country? What happens to the stock?
I'm not a stock analyst. I have no idea.
But you're a brilliant man. I want your opinion.
I have no opinion on matters of the fiscal
Stock.
health of a publicly traded company. I have no idea.
For the record, you have no opinion of what it would do to the stock.
None whatsoever. It's not something I've ever thought about.
I think you should sometime. Mr. Chairman,
right.
thank you.
All right. Any other questions? Mr. Manuel, thank you for being here. By the way, I'm about halfway through your book. I
hope
think
you're
there's
enjoying
also evidence that custodial arrests on the misdemeanor side also produces probably some positive effects
Indeed.
as the Broken Windows project. But thank you so much for being here.
Thank you for having me. Really appreciate it.
All right, next is Mr. Ben McGowan and from the Tennessee Association of Criminal Defense Lawyers and Lindsay Holloway from This Is Living Ministries. If you'll both come forward and have a seat and state your name for the record and begin.
Thank you, Mr. Chairman. Thank you, honored committee members. My name is Ben McGowan. I'm with the Tennessee Association of Criminal Defense Lawyers, and my members have asked me to come here today to speak to you about the Bill 1030, which is before you. I think primarily the point I want to get across at the outset is that Tennessee has done a very good job of being both tough and smart on sentencing. We have, since the Sentencing Reform Act, put into place a variety of mechanisms that this state has at their disposal. And in so much as I don't disagree with Mr. Mangual, we have robust sentencing procedures in this state that need to be enforced. We have consecutive sentencing availability. We have life without parole. We have an existing three strikes law for violent felonies. Really what we see this law is doing is expanding that to lower level felonies, to in some cases misdemeanors, to circumstances under which a misdemeanor, an abuse and neglect charge, can result in treatment as a serious violent felony under this three strikes law. And so from the circumstance of the public, how they perceive what violent crime is, there is no disagreement. We have a violent crime problem, and incapacitation is one peniological strategy that Mr. Mangual spoke of. People you cannot reach who need to be put away. But under this, there are people who will have C and B misdemeanors and A misdemeanors that will be treated as violent felonies. And that is not what the people of Tennessee expect from our judicial system. So from the position that practical matters, we have concerns about the fact that once you start taking low-level felonies and using them in this matrix, you will reduce pleas, you will force competent defense lawyers to litigate lower-level felonies much more seriously than they otherwise would have, because they are going to be concerned about amassing points on someone's record. That person may never get into serious violent trouble, but any competent lawyer is going to litigate those cases in a way that they did not before, because we have this matrix, when in fact we already have a sentencing structure. And we have all these mechanisms that judges can put into place. Career sentencing. We have consecutive sentencing. We have the existing three strikes. We have maximum statutory mechanisms at our hand. So I would just ask of this committee, before we create another law on top of this frankly hard to manage bureaucracy of calculating lesser points and more points. I think Ms. Mangual's point about being able to reduce points is an interesting one, and maybe that's worthy of some study. But for now, what we have is an existing structure that we are layering on. We cannot legislate ourselves out of crime. We have the tools at our disposal. Our legislature has done an excellent job of creating those tools. It is a matter of using them. I ask that you would reach out to constituents in your area, judges, sheriffs, folks who will be impacted by this. We will see defense claims and public defender caseloads skyrocket as a result of the necessary work that's going to have to be done if we include these low-level felonies. So I appreciate your time today, Honorable Chairman and committee members. It is nice to be able to reach you on behalf of my membership, and if you have any questions, I would love to answer them.
Okay, any questions for Mr. McGowan? Representative Johnson.
Thank you. And as I understand it, it's going to be, you said something about it's going to be more difficult to make these plea agreements, which is going to bog down the process. Is that?
I think that's fair to say. I think that one of the issues is that people are going to begin to think much harder about accepting responsibility for bad behavior when they know that can form a predicate in the future for life without parole. And so I think that we are going to see some system of slowing in the criminal courts, whereas cases which would have easily been pled, cases where an agreement would have been reached and someone would have been punished, now will result in more long-term litigation.
Okay. And also, can you give me some examples of those low-level crimes that, somebody might have committed a violent felony when they were younger, but you have these other non-violent crimes. So what sort of crimes might that entail?
Yes, Representative Johnson. So the bill encompasses a number of D and E felonies. It also notably encompasses facilitation, attempt, and conspiracy, all of which are inchoate offenses which drop the level of punishment down. So with an E felony, if you're convicted of facilitation, that would in fact be let's say an E felony sexual battery, would be a B misdemeanor for facilitation of that crime. The net result is that we have a number of misdemeanors as based on attempts and other inchoate crimes that then would be calculated in the system. There are some that are built into it already as A misdemeanors, and I think the example that comes to my mind is the abuse and neglect of a child, which can be a higher level felony, but also goes from a D to an E to an A. And no one does not deserve to be punished for abusing a child. There's no controversy there. What we have to keep in mind, though, is that some of these offenses are very complicated and have multiple factors involved, and may involve a disruptive household where it's not clean and there are cockroaches and things of that nature. Horrible circumstances, to be sure, but also very often tied in with mental health issues, often very tied into socioeconomic issues. And so I'm not trying to offer up a parade of horrors. There are some protections in the proposed bill, such as that there be the existence of 2 violent felonies before you can begin to accrue these minor point offenses. But we have a 3 strikes bill. We have a bill for 3 violent offenses. And that is really, I think, how the committee's time is best spent, is exploring how to refine and rejuvenate those sentencing procedures and educating prosecutors and judges on perhaps consecutive sentencing and more useful tools. It may be a perception of many in this room, but I spend every day of my life in criminal court, and I simply do not see the prison doors swinging open and going around. We definitely have a crime problem in this country, but the people that this bill would seem to target are the people that I know who are doing 60 years, who are doing 90 years, who are doing life or life without parole. And so, therefore, I'm not going to say this is an imagined problem, but to some degree, I do think it reflects historical trends of trying to legislate out of crime, and presents for us an opportunity to create new legislation when in fact we have an existing superstructure that is more than equipped based on your hard work in the past.
Thank you.
Vice Chair Gillespie.
Thank you, Mr. Chairman. I just heard you say something. Thank you for being here. I just heard you say something, and I hope I misunderstood it. Did you just say that you, in every day that you go in criminal court, that you have not seen a revolving door in our criminal justice system? Did I hear that correctly?
Well, I haven't, quite frankly. In terms of the folks we're talking about, in terms of the serious violent offenses. Now, I happen to be blessed in a jurisdiction where we have judges who understand the sentencing laws and who do a very good job of balancing sentencing questions. But no, in my experience, what I see is that the people that a law like this would punish, the people that we think of collectively as repeat violent offenders, are the people who are doing long prison sentences in my jurisdiction. And I can't say that's representative, but I've practiced in several states and in a number of counties in Tennessee. And Tennessee, I have found in my experience to be the strongest and in many ways the smartest on sentencing. That there is an understanding of the usefulness of incapacitation. There's an understanding on this side of the continuum of the usefulness of rehabilitation, and that, you know, those two things on the end of those continuum are well enforced.
Okay. I don't know if I'm going to throw a bunch of judges under the bus here or who I'm throwing under the bus, but where I live and the people I represent do see on a daily basis this revolving door. We are being plagued by both juveniles and adults that are repeat violent offenders that are going in and out of the system on a daily basis. I've talked to multiple police officers and deputies who have arrested the same juveniles for the same violent crimes in the same week. That is a big problem, especially now that those people are killing people while wearing ankle monitors. That is a clear indication that there is a revolving door, and to the point that this bill is trying to address.
Well, respectfully, I think we're on the same page. I think that What's happening there, as I see it, is a breakdown in the enforcement of the existing laws. What I see there is you're talking about people who are in and out committing serious violent offenses, which are already encompassed in our sentencing structure. And so maybe what's happening is inappropriate plea deals. Maybe what's happening is cases are not well investigated or are falling apart. I don't know what the cause there is, but it's certainly not a lack of meaningful, enforceable legislation that exists, because when we are talking about, really what this bill does is, in my reading, is it encompasses, it throws in a number of lower level, not to say not serious, every felony is serious, Chairman, but to say lower level offenses that then just accrue over time, and which also creates an issue of who manages this numbers game of these offenses. If we had a true will among the judiciary or the prosecutors to enforce the existing three strikes law, we would have what this bill proposes already in existence. And so that's why I think tweaks that merely seek to sweep in less serious offenses that society in general would not think, well, that fits naturally into a repeat violent offender statute. That would be a disconnect for your average citizen who would see that. When they see three home invasions, when they see a rape, a home invasion, and a second-degree attempted murder, they know that person is somebody who, in all likelihood, belongs safely ensconced away from society for the rest of their lives. But when they see somebody who's had a succession of felonies and in their youth had 2 violent offenses, and yet they're going away for life without parole after getting a certain number of relatively minor felonies, I think a lot of people in our society are being inclined to say, that just isn't fair.
Go ahead.
I hear what you're saying. I think my constituents, the people that I'm responsible for, would say differently. And I would also say that if you were to go down to 201 Poplar in Memphis and poll both people that are about to be going on trial and the people that are being brought in on charges, and you polled them, I would bet that you would have a very different story. Thank you so much for being here.
And I respect that.
Representative Hardaway.
Thank you, Chairman. I was trying to get into a lot of what my colleague was saying, so I don't have all my questions as organized as I had them initially. But what I've not heard today has been any deliberation on how some of the nuances, such as age, factor into the equation of repeat offenders. If I'm going to lock you up forever, does that mean that when you're 90 years old that I consider you a threat to society? How, as I inquired with the gentleman earlier, are we able to assess the variables within that individual's life? We make a big deal out of understanding adverse childhood experiences. It's my theory that we also have acute chronic trauma for adults. And I don't see that being figured into these algorithms or equations that we're using to lock folks up forever without reevaluating where they are, without assessing, are they at the point now to where they've the combination of rehabilitation has worked, or that they are just because of physical disabilities or otherwise just ain't no threat no more. But I'm not convinced by the numbers and the lack of metrics that the gentleman had, and I want to get your opinion on that.
Well, I think certainly anytime you're talking about taking a human being and putting them away forever based on misdeeds in their lives or sometimes even horrific things that they've done, human beings are changeable. And the reality is that citizens have a right to be fearful of people when they have shown their behavior to be worthy of fear. However, as you point out, the human being is highly changeable, and it's beyond the scope of this bill. But there does not appear to be any mechanism for recognizing one's ability to change over a lifetime. It's beyond the scope of what I have presented, but I would certainly say that many of my members are great believers in second chances, and are great believers in the capacity of human beings to change, and that there should not be the existence of a system that doesn't recognize that. So I hope that addresses your question. I'm not sure it does.
It does, and I thank you, Mr.
if-
Chairman.
Representative Hardaway, if you don't mind, we're going to run here till we run out and not even have time to pass bills. And I want to get to Ms. Holloway. So, Ms. Holloway, would you begin, please?
Yes. Thank you. It's an honor to be here. I hope that my story can help inform this important decision you're making. My name is Lindsay Holloway, and I am actually a formerly incarcerated person. I am now the founder and executive director of a women's reentry home in Cookeville, Tennessee, where we help women every single day coming out of incarceration. And I understand this because I've lived it, and now I get to live it every day, seeing women be restored and be transformed and be new. Due to the recent tragedies, I know this is all on the hearts of everyone in our state and our committees, and for good reason. However, this three strikes law, although well-intentioned, is not the proper response, I believe. House Bill 1030 would increase the use of automatic life sentences without parole for individuals with multiple convictions. I myself was arrested from the time I was 18 to 24 due to childhood trauma, due to substance abuse, and undiagnosed mental illnesses. I was given the option by a judge, and the judge was given the leeway to give me a sentence that would get me the help and the treatment that I needed. But had this bill been in, I could have been one of these people that you're talking about that had the low-level offenses. I had all misdemeanors and then finally a felony, but that felony was in the federal system, and the federal system actually looked at me as a person, my background, my history, and they sought me services. And I was able to go through 2 years in a program on probation and get tons of counseling, mental health services, and now I'm 13 years later, and I run an entire organization. I've helped hundreds of people. I work in the prisons, and I think we have to look at this as people have human dignity, and justice needs to be done, but people also need to be restored, because now my daughter won't have to go through the trauma that I went through. My daughter will grow up in a home where she's learned these behaviors, and she's learned what's not okay. She's learned counseling's okay. So personally, for myself, I feel like incarcerating people for these decades long behind bars, most studies, if you study states that are like Tennessee, not California, longer prison sentences don't lower the crime rate. The studies show that they don't. And if we aren't restoring people back to their homes, we are causing more victims, because their children are 70% more likely to follow them. So I believe that, with the women that I see, the things we do have set up, and Tennessee's done a good job of, is setting up the programs. Now I'm seeing lots of prisons are doing trades training. My husband went through trades training. As soon as he got out of prison, he actually opened a carpentry business. That carpentry business has paid our bills for the 2 years it took us to get this nonprofit off the ground, where I had no paycheck. He's used that trade to train other men coming out of incarceration. Now we have a wood shop that we're using to train our ladies in entrepreneurship, where they can get jobs, like you were saying, because a lot of people wouldn't give us a chance. They wouldn't, so now, like, I work for a nonprofit where nobody has to do a background check on me. My husband owns a business where no one has to do a background check on him, and we've done that successfully. We've paid off all our debts to society, which is over $50,000 between the two of us, and now we are making a difference in our society. And I think things like this are going to get people like us that just needed help, instead of people that were all the violent crimes, like he said, that we already have laws for.
Okay, Representative Johnson.
Thank you, Mr. Chairman, and thank you so much for your testimony. It's so important to see the faces of the folks who have come through this and come out better on the other end. It was distressing to me to hear from someone, I'll just be honest, earlier, the gentleman who thought we should just lock everybody up and throw away the key even before they've committed those crimes, and see that that we can prevent, we can help people and get them on the right path with the right policies. And as we've demonstrated, we already have the sentencing ability for 3 strikes and all these other things. And so we should use the tools that we have, but we should also just focus also on preventative and rehabilitation and all of those things. And the idea that low-level offenses can get someone to that place should be incredibly scary to everyone.
Yeah.
And so thank you so much for being here.
All right. Ms. Hollowell, thank you so much. Okay, Mr. Towns, Representative Towns, can you hold it maybe just limited so we can move out of here?
Yes, sir. I'll try to do exactly that, Mr. Chairman. Look, you may or may not know this, but thank you for your testimony. Whatever the young man hear this, because he needs to hear this and put this in his book. Okay. Matter of fact, I'll send him a text on that. This is the deal. What percentage of people, either one of you all, can tell me, or anyone in the room that knows, what is the percentage of people that commit crimes, let's say violent crimes, and they were mentally ill at that time, severely mentally ill? Give me some idea.
I'm not sure on that one, but I know from the ladies that I've helped over the last, the ladies I've helped over the last,
Red button.
that one? Is that better?
Yes, ma'am.
Okay.
Yes, ma'am.
From what I've studied with the ladies that have been through our program over the last 5 years, almost 90% of them scored extremely high on the ACEs, which actually, if you go through childhood trauma at that young age, that actually causes mental health issues. And I think almost every one of my girls has had to go for mental health help, medications, things like that.
The statistic I can give you, Representative Towns, has to do with the juveniles. Has to do with juveniles, and it was in preparation for another bill that was rolled. In Knox County, the number that I heard was that students with disabilities and mental health issues make up 12.5% of the student population. They make up 50% of the juveniles going through the juvenile court system. You know, that alone is a fairly startling statistic.
Mr. Chairman, thank you for that. Finally, I asked you guys, what percentage of them are getting quality mental illness intervention while they're incarcerated, if that goes on at all?
About 60 seconds, sir, please.
Please, shortly.
Very few. I realize that's not a percentage. It is very difficult to come by meaningful mental health treatment in the custodial setting.
Okay, thank you so much. I appreciate you both being here. We're going back in session. Chairman Doggett, you recognize.
Thank you, Mr. Chairman. Thank you for all those that have been here, the questions and things that have been asked today. I would move that we roll this bill 2 weeks.
Bill rolled 2 weeks. We're now on House Bill 1002 by Leader Lambert. Got a motion? Got a second? Leader, you're recognized.
Thank you, Mr. Chairman. There's an amendment that makes the bill, and that is amendment coded 5770.
5770. We have a motion and a second on Amendment 5770. All those in favor say aye.
Aye.
All opposed, no. 5770 is on the bill. Go ahead.
Thank you, Mr. Chairman. In death penalty cases, this gives exclusive control over the state's defense of collateral review to the Attorney General's office.
All right, are there any questions for the sponsor of the bill? Question been called on the bill. We're voting on House Bill 1002. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Bill moves on to calendar and rules.
Thank you, Mr. Chairman. Members of the committee.
Thank you. All right. Item number 4 on the calendar, House Bill 1242 by Powers has been rolled 1 week. Item number 5, House Bill 1248 by Powers has been rolled 1 week. Now we're on item 6, House Bill 0248 by Representative McCalman. That's right, I wrote that down someplace. I'm sorry. That bill is rolled to the enhancement calendar. So that about does the. All right. If you're as hungry as I am, is there a motion to adjourn? All right, we're adjourned.